Good morning, everyone. It's my great pleasure to introduce our first speaker for this morning, Associate Professor Scott Stephenson, who was educated at the Australian National University, where he obtained a Bachelor of Arts. I'll start again. I want to do you justice, Scott. So, Associate Professor Scott Stephenson, he was educated at the university, the Australian National University, where he obtained a Bachelor of Arts and a Bachelor of Laws with honours with the University Medal in Law, before he went on to obtain a Master's and a JSD from Yale University. He was Associate to Justice Virginia Bell AC. He's held visiting positions at the University of Cambridge, the University of Copenhagen, King's College in London, and the University of Oxford. He is the Treasurer and a Council Member of the Australian Association of Constitutional Law. He is now an Associate Professor at Melbourne Law School, and his research focuses on topics of Australian and comparative constitutional law. He's published in leading Australian, Irish, UK, US and international journals. Everyone, would you please welcome Associate Professor Scott Stephenson.
Okay, good morning, everyone. I'd like to begin by acknowledging the traditional owners of the lands on which we meet, and I'd also like to thank the conference organisers for inviting me to speak with you today. As I was mentioning to Nick before, I would absolutely love to stay for the full day's presentations because there are so many interesting papers, but unfortunately I'm currently engaged in the country's favourite weekend sport, the purchasing of residential real estate. I can guarantee you that you'll be having more fun today than me. Okay, so I plan to address the question of whether the voice is constitutionally conservative. Before I set out how I'm going to proceed, I will make 3 disclaimers about the questions that I am sort of not addressing in the hope of avoiding at least some confusion about the claims I'm making. So to begin first, I'm not speaking to whether we should have a First Nations voice. Other people far more qualified than myself have made very convincing cases both for and against a voice far more eloquently than I ever could. My interest instead is the precise form of the institution that has been proposed, and in particular, how we should characterise it. Second, I'm not speaking to whether the voice is politically conservative. In the United States, as many will know, the distinction between constitutional conservatism and political conservatism has somewhat collapsed, at least in common parlance, as some political conservatives have sought to rebrand themselves as constitutional conservatives. That has largely, I think, not occurred in Australia, so it is possible for us to speak meaningfully about the subject without conflating the two terms. And I think that that is a great feature of Australian discourse, because they do refer to distinct concepts that are not necessarily correlated. To put it in overly simple terms, the constitutional conservatives' interest is the institution of governments established by the Constitution, while the political conservatives' interest is the set of policies implemented by those institutions of government. I have nothing to contribute to that latter interest today. Third, I'm not speaking to the merits of constitutional conservatism. That is a much larger topic, I think, than I can possibly deal with, that has quite a lot of interesting complexity. One might, for example, advocate for a constitutionally conservative posture in relation to some legal and constitutional issues, but not others. As a result, I simply just don't have the space to talk about that today, given that I want to speak about the voice in some detail. So then, turning to the question that is posed by the title of my talk, the first step is, of course, to say something about what I mean by the term constitutional conservative. Now, I think everyone, both here and in the sort of broader legal community, will have a slightly different understanding of that term. And so in this sense, I can only give you sort of what I understand it to mean broadly, which is in the context of constitutional change, an approach that seeks to maintain fidelity to the core tenets of the existing system of government, to truncate and adapt Michael Oakeshott's writings on the subject of conservatism. A conservative disposition towards constitutional change prefers the familiar to the unknown, the actual to the possible, the limited to the unbounded, the near to the distant, and the convenient to the perfect. There are two aspects of the voice that are most commonly said to reveal its constitutionally radical character, one relating to means and the other relating to model. The first is that the voice is being pursued by means of constitutional amendment. The more constitutionally conservative option is said to be statutory reform. The second is that the model proposed for the voice allows for it to make representations to the executive. The more constitutionally conservative option would be, it is argued, to confine its representations to Parliament, because of course that would limit the legal uncertainty of the proposal and would help stop the voice from being able to potentially disrupt the operations of the executive arm. I think on first glance, both arguments appear self-evident, almost to the point that one might call them trite. How could it not be constitutionally conservative to select an approach that involves no amendment to the constitutional text? And how could it not be constitutionally conservative to opt for a new institution that is given narrower rather than a broader set of powers? So in the interest of trying to be as provocative as possible, what I want to suggest is that perhaps once we appreciate the totality of the system of government established by the Constitution, the current approach might be a little more constitutionally conservative than this first glance suggests. So let me begin with this first contention, that a statutory option would be more constitutionally conservative. It cannot be the case that a conservative disposition requires no amendments ever to be made to the Constitution. That would, I suggest, be a quite radical constitutional position, because it would render Section 128 otiose. And that provision is a central pillar of our existing system of government. Its existence in the constitutional text confirms that our existing system of government contemplates change, and contemplates that this change can occur, at least occasionally, through alteration of the constitutional text. In this regard, we can draw a comparison with the British North America Act of 1867, which contained no provision for its amendment. That left Canadians with difficult questions about the extent to which its constitutional text contemplated change and the appropriate procedure for doing so, especially as Canada became an independent country. That issue was one that continued to affect a Canadian constitutional discussion at least until the enactment of the Constitution Act of 1982. In Australia, the question must therefore be when constitutional change should be pursued by means of amendment rather than statute. And I hope it is obvious that I'm speaking here of small c constitutional change, so constitutional change in its broader understanding, rather than capital C constitutional change, because of course amendment of the words of the Constitution must by definition occur by means of amendment. So in some cases, the answer as to which path to take is of course straightforward. Altering the size of the High Court from 7 to 9 judges is a constitutional change that can clearly occur by means of statute, because Section 71 expressly confers that power on Parliament. Conversely, reducing the size of the Senate so that each state had a mere 5 senators is a constitutional change that can clearly occur only by means of amendment because Section 7 guarantees each state at least 6 senators. However, there is a vast middle ground where Parliament might be able to pursue constitutional change by means of statute or by means of amendment. My argument is that at least in some instances, the more constitutionally conservative option is to seek an amendment on the basis that the change, if successful, would alter the system of government contemplated by the Constitution, even if there isn't sort of some express constitutional prohibition on reaching that change. In these circumstances, pursuing change by means of an ordinary statute is arguably the more constitutionally radical option because it pushes up against the basic bedrock principle in Australia that the people have the final say on the fundamental structure of our government, a long-standing principle that can be traced back to the process for approving the original Constitution, that is reflected in the constitutional amendment procedure in the text, and that is affirmed by the 44 referendums that have been held since 1901. To illustrate the point, let me begin with an example that does not involve the voice. Say the Commonwealth Government wanted to introduce an entrenched Bill of Rights that gave the judiciary the power to invalidate primary legislation for incompatibility with rights. This is undoubtedly a change of a constitutional character. Now, the Constitution does not expressly tell us whether this type of change requires an amendment. It does not expressly preclude the enactment of a judicially enforced Bill of Rights, and it does not expressly preclude Parliament from taking steps that would bind a future Parliament, either directly through an entrenchment clause, such as a manner and form provision, or indirectly through some practical feature that would make it exceptionally cumbersome and costly to unwind. However, it is arguable that the more constitutionally conservative option would be to pursue this type of change by means of amendment, because it would restructure the relationship between the three arms of government that is contemplated by the Constitution. To attempt this by means of statute would arguably be considered more constitutionally radical, because it is opting for the riskier, the more contestable and the less inclusive path of pursuing the outer and pushing the outer limits of what can be done by statute, rather than the safer, less contestable and more inclusive path of following the procedures set out in Section 128, which unquestionably would allow a change of this character to occur. Importantly, this argument holds regardless of whether the High Court would invalidate the statute for incompatibility with the Constitution. An act's constitutional validity is separate from that action's constitutional conservativeness. There are more conservative and more radical ways of achieving the exact same change to Australia's system of government, just as there are more conservative and more radical ways of travelling to the exact same destination. Indeed, if we think a change of this nature should have occurred by means of amendment, any court decision that upheld this change by means of statute would form part of the reason that we consider that action to be constitutionally radical. Say, for example, Commonwealth Parliament sought to declare Australia a republic by statute, as some have suggested might be possible, and the High Court upheld the validity of that statute. Part of the reason that move would be considered constitutionally radical is that the vote of 15 million Australians has been substituted for the vote of 7 judges about a question on a fundamental feature of our constitutional system of government. Now, this same line of reasoning can be applied to the voice, I think. The Constitution has always governed the relationship between the state and First Nations, both directly through provisions such as sections 25, 51, 26 and the now repealed 127, as well as indirectly through its existence as the founding document for a state that claims sovereignty over land which First Nations have not ceded. So as the text of the proposed constitutional amendment states, the purpose of the voice is to recast that relationship by recognising Aboriginal and Torres Strait Islander peoples as the first peoples of Australia. It is therefore, I think, arguable that the more constitutionally conservative option is to attempt such a change by means of amendment rather than statute. Put alternatively, one could reasonably posit that if Australia is going to take the step of altering its system of government by recognising the first peoples of Australia and creating a new institution as part of that recognition process, the path that leaves no doubt that it is an alteration of that system is the one that first seeks direct approval from the Australian people following an extensive national debate. So now let me turn to the second argument that suggests a more constitutionally conservative model could have been chosen for the voice. Now, my focus is on the particular configuration of the voice. I don't have a lot to say about the selection of the voice as opposed to other potential ways of recognising First Nations peoples, but I will observe in passing that there's at least an argument that of all the ways to recast that relationship between the state and First Nations, Aboriginal and Torres Strait Islander peoples have advocated for what is probably, at least in comparative perspective, one of the more constitutionally conservative options. A body that advises existing institutions of government is probably a more conservative choice than, for example, seeking a judicially enforced right to non-discrimination on the basis of race, as was suggested at some points in the process, some form of full self-government, a duty to consult and accommodate before any government decision is taken on Indigenous affairs, or any number of other options that are seen around the world. In this way, they have arguably preferred the actual to the possible, the near to the distant, and the familiar to the unknown. But turning back to my focus on the model for the voice, the argument is that it would have been more constitutionally conservative to confine the voice's power to make representations to Parliament, as opposed to the proposed model, which confers power to make representations to both Parliament and the Executive, as we all well know. When designing a new institution, the more constitutionally conservative option is arguably one, as I have suggested, that aligns with the existing system of government, rather than one that may require significant changes to that system. As is well known, Australia's constitutionally prescribed system of government does not establish a strict separation between the executive and the legislature, either in terms of membership or function. That is confirmed by both the constitutional text, with provisions such as Section 64 requiring ministers to be members of Parliament, and constitutional practice, with, for instance, the long-standing tradition of the executive exercising extensive lawmaking power on delegation from Parliament. Permitting the voice to make representations to both the executive and the legislature would therefore, I suggest, map more closely to the existing system of government, which does not observe a bright line distinction between those two arms. Many issues that affect Aboriginal and Torres Strait Islander peoples arise either very early on in the lawmaking process when government policy is first formulated, or at the very end of the lawmaking process when laws are implemented on the ground by government officials. As a result, it is reasonable to expect that if a voice is created, it will seek to make representations on these matters. It might be quite disruptive to Parliament's operations for it to receive and assess representations on these matters, given that its resources, its expertise, its structures and its procedures are directed towards the middle of the lawmaking process, where legislation is drafted, refined, enacted and reviewed. It would arguably be less disruptive for the voice to be able to make representations directly to the part of government that is responsible for the issue that it wishes to petition the state on. But, of course, would it be more disruptive for the executive? When considering the answer to this question, where people will obviously have very different views, I think it is important to keep in mind that one of the executive's core functions that it has exercised for many decades is to receive, synthesize, and respond to inputs from quite a wide range of actors, including oversight bodies such as ombudsmen and auditors general, statutory agencies, members of the public, other governments, both foreign and domestic, external consultations, international organisations, domestic organisations, lobby groups, parliamentarians, and on it goes. So at least in one respect, this would not be new territory for the executive. Now, one might contend that the more constitutionally conservative option would be to entrench no aspect of the voice's power to make representations and leave Parliament to determine the full scope of that power. However, I'm of the view that there is probably not a strong evidentiary basis on which to make that point. It is certainly contestable, but in general, the Constitution entrenches the power of each institution it establishes. Parliament is typically given a wide degree of latitude to control, regulate, and amplify the powers that each institution exercises, but it is generally not given the ability to completely define it. Sections 1, 2, 61 and 71 all stand as examples of that approach. But there is, of course, the possible counterexample of the Interstate Commission. What I would suggest, though, is that it is noteworthy precisely for its exceptionality. I'm not confident that one can say that the more constitutionally conservative option is to follow an institution that is broadly considered to be a constitutional outlier and that has been defunct for several decades. Perhaps, but I think the weight of evidence lends to the other direction. Finally, I do not see the Voice's ability to make representations to the executive as necessarily increasing the constitutional uncertainty of the model. As I've written in a post on the Australian Public Law blog, many concerns about the legal uncertainty of the model run together constitutional and non-constitutional forms of uncertainty. And I sort of point out in that post that we have to remember that that latter form of uncertainty does exist around the enactment of all statutes and is capable of rectification by Parliament through the ordinary lawmaking process. So as I argue, our focus really should be on the constitutional forms of uncertainty, because that's the type that needs to be considered before all of us vote in the referendum, and because it is not capable of easy rectification. On that topic, there is absolutely some uncertainty created by entrenching the Voice's power to make representations to the executive. It, for example, raises questions about the scope of Parliament's power to regulate the Voice's powers under Section 129, subsection 3 of the proposed provision. But I would also point out that it does reduce constitutional uncertainty by eliminating questions about the limits of the Voice's power to make representations to the executive through Parliament. We would not face questions, or are at least not likely to face questions, about the constitutional validity of representations from the Voice that sought to turn Parliament, perhaps with the help of a sympathetic parliamentarian or two, into a mere conduit for representations to the executive. In other words, it eliminates the sort of questions we have seen arise in the context of Section 96 by allowing the Voice to go directly to the intended recipient. So in conclusion, I've sought to put forward a case that the current model for the Voice is perhaps somewhat more constitutionally conservative than it might first appear, because the more conservative option is arguably to opt for amendment over statute when seeking to modify a fundamental aspect of our system of government that the Constitution regulates or at least contemplates, such as the relationship between the state and First Nations, and because the model chosen for modifying that relationship is arguably a conservative one from a design standpoint, permitting the voice to make representations to both Parliament and the Executive allows for it to align its functions with the system of government that has been very well established by both the constitutional text and the constitutional practice. So I hope that has been sufficiently provocative to make getting out of bed on a Saturday morning worthwhile. Thank you very much.
Thank you, Scott. That was wonderfully thought-provoking, and I think the caffeinated equivalent of about 3 Red Bulls on a Saturday morning. I have many, many questions, and I imagine you probably do too. Now, we do have the roving mics. Just a reminder to don't start speaking until you've got the mic in your hand and speak into the microphone. So we'll take questions now. Yes, gentlemen, just coming down here.
Well, thank you for calling me, gentlemen. I don't get that very often. James Allen. So firstly, let me just say I thoroughly enjoyed that. And I don't expect normally to enjoy stuff that's coming out of the University of Melbourne, so that was terrific. So I agreed in a way with everything you said, but let me just push back in this sense. When you're talking about what it means to be a conservative, of course, you cannot really think about it in a substance-free way. You know, an attachment to existing institutions, an attachment to existing arrangements doesn't really make sense without some first-order values. Presumably no one's a conservative in North Korea. And so the attempt to sort of bifurcate or draw a hard distinction between conservative and constitutional conservative, that's what I want to push back and ask you what you think. So leave aside the voice. Take something like the Love decision, right? And so if you're really asking yourself what is most in keeping with existing arrangements, whether just to leave the horrible decision in Love alone, or to invoke either a new case, which Labour pulled, or even a constitutional amendment, you can't, I don't think, really answer that question without first having a set of conservative substantive views. Whether you're more attached to letting the judges change things through time, or to a pre-existing view of the Constitution. And so I'm not exactly sure that I couldn't stand up there and do exactly what you did, but come to a completely different set of answers and still abide by every single one of your premises. I'm just not sure you can make in other words, this is a conservative, I want to keep that distinct from this is a constitutional conservative line of argument. Maybe you can. It's very thought-provoking, and thank you very much.
Alan?
So thanks so much. It's a really interesting question. And it's perhaps one that's like way too big for me to try and answer here, but let me have at least a go at it. I agree with you that it's going to be very hard to work out, what exactly the commitments are of a constitutional conservative. I think that's and to what extent we can. I don't think it's ever going to be sort of truly sort of value-free or some sort of completely neutral thing. But I also think that in the sense that, it also perhaps depends, on what you understand, what values are required to be a constitutional conservative, in the sense that to believe in particular institutions is also to have sort of certain values. And so in the sense that, if you're committed to federalism, which I think is probably a commitment of constitutional conservatives, given the long-standing sort of history and importance of it to the constitutional text, but that in that sense, that's not an entirely sort of value-free commitment, as federalism does sort of have all of these sort of substantive governance commitments embedded in it. And then when it comes to the Love and Tom's decision, there is this idea of, well, what sort of commitment would you, or how would you rule if you were a constitutional conservative? So I think sort of to start sort of perhaps more broadly with the idea of, well, how do we interpret the heads of legislative power? I think there is a constitutional conservative argument that is, if you're trying to really push the boundaries of the heads of legislative power, the appropriate role for a court, a high court that is sort of committed to constitutional conservatism, is to tell Parliament, well, if you want to make a change that's going to fundamentally reorient the federal system of government, go back and attain the assent of the people first. So one of, sort of my commitments is that actually we should have a much more open and embracing stance towards constitutional change, in the sense that, if you want to sort of take over industrial relations, for example, or legislate with respect to the environment, you shouldn't be able to perhaps push that through the external affairs power or the corporations power. You should go back and ask the people whether they assent to a particular restructure of the federal division of powers. Now, coming to the sort of Love and Tom's decision more specifically, that obviously turns on the interpretation of alien. I think I'm not sure that there's one necessary sort of answer in terms of how a constitutional conservative would sort of address that. I think there can be sort of arguments made, on both sides that, to some extent, if you're sort of going to run a particular conception of this, you should go back to the people and ask for it. But then there's others that it's like, well, the more conservative disposition is to basically defer to Parliament's judgment about what is and is not an alien. And so in that sense, I don't think having a constitutionally conservative disposition answers all questions. And I think in this one, you could actually legitimately disagree if, two constitutional conservatives could get up and reach opposite conclusions on Love and Tom's. And I think that's, completely fine. That's the nature of these sorts of approaches, that they perhaps point towards some conclusions as opposed to others, but they don't resolve everything. And I could completely understand someone coming up here and reaching the opposite conclusions and sort of saying, well, from a constitutionally conservative perspective, the most conservative option is to go for statutory reform because it's the most incremental, and to opt for just Parliament only on the basis that, we favour incrementalism as a constitutional conservative. I'm sort of just trying to put an alternative approach to that. I'm not saying it's the only conclusions you could reach from it.
Got another question over here at the top.
Hi, John Story from can you hear me? From the IPA. Thanks for your presentation. It seems to me that there's something of a logical dilemma in the framing of your question. The Prime Minister says the voice is a modest request. So if it's modest and if it's purely an advisory body, there's nothing particularly unusual about Parliament legislating to create some sort of advisory council or board of, it's nothing particularly unusual. There's all sorts of forums that are set up outside of the Constitution in which the government of the day seeks advice. But if this is a more fundamental change to the system of government, I would agree with you, it would be right that that be put to the people and enshrined in the Constitution under Section 128. But that is not what's being sold. It's being sold as a modest request. So which is it? If it's a fundamental change to the system of government, I agree, it should go to the people. But that's not what's being sold.
Wonderful. Thanks so much for the question. So I don't, have any sort of views on, the messaging or things like that. I'm not that's not something that I, have a particularly strong view on. But I think what we have to perhaps sort of do when we're trying to characterise the proposal that's being put to the people is to look at the language and the text that's being proposed. So in that sense, what the text of the proposed Section 129 suggests, that it is part of a recognition process of recognising Aboriginal and Torres Strait Islander peoples as the first peoples of Australia and establishing a new institution of government. So at least from that perspective, I see it as something that is not just another advisory board. And so at least I think to the extent to which there's been a lot of discussion and debate in the media about sort of talking up its potential impacts and significance, and then also talking down. And the same people are often saying this, the opposite messages depending on who they're talking to. So I think that's sort of just an inevitable dimension of a political campaign, and it's also something that happens before the High Court, as in this is something that the judges get very annoyed at with advocates, as in talking up the effects of a statute to increase your chances of arguing it's constitutionally invalid, but then, once it's applied to your client, arguing for the most minimal interpretation. This is sort of something that just happens in advocacy all the time. But I would sort of adopt that from both the origins of the voice in terms of the Uluru Statement of the Heart and what's claimed there, and the sort of text of the proposed amendment, that it's more in that sort of latter category. It's not just any old sort of advisory body. It's something that goes to essentially the heart of the relationship between the state and First Nations peoples. But I think, in terms of the actual model that's been proposed, as I sort of suggest in the second half of my paper, it's probably one of the more constitutionally conservative models that could have been chosen. Maybe not the most, but in that sense, it's sort of, perhaps its ambitions in terms of the relationship, it is somewhat ambitious, but in terms of the actual model it's chosen, it's not one that sort of, at least on the text, has any veto power or anything like that. I know that probably doesn't fully satisfy you in terms of answering your question, but that's probably as far as I can go.
Ben?
Thanks, Robin. Thank you, Professor. Can I ask a question which draws on your comments by Michael Oakeshott, and can I be so presumptuous as to put some words in the good Mr. Oakeshott's mouth? He might have favoured the more predictable over the unpredictable. One of the things that's said to be unpredictable about the voice and how it might work is its right to make representations to the executive, and then what obligations fall on the executive to respond to those representations. And given that it is a constitutionally entrenched body, is that going to give a greater level of obligation on the executive, and is that going to be unpredictable? So my question is this getting us into some novel territory where there aren't precedents in terms of obligations on the executive, and would you, dare I say, be able to predict where that might lead?
Thanks. This obviously goes to one of the biggest sort of questions about the design choice, obviously, and I think this is a really interesting question. I think, and I sort of talk a little bit about this in the Australian Public Law post, so if you want sort of some views of mine on that point, I've set them out there. I think I would also perhaps add to that, I think the perhaps one of the more convincing, at least to my view, sort of responses to that question is, I think it's Craig Lenihan has sort of published a post about the sort of legal uncertainty in relation to the executive on the Australian Public Law blog. So to some extent, I'll adopt his views on this. But I think in terms of this, there's certainly going to be some novelty here. There's no doubt about that. And so it's really a question of trying to understand the degree of uncertainty that's being added here. And I think when it comes to sort of the potential for, say, administrative law review of decisions for failing to heed the voice and so forth, that it will probably follow the patterns that we've seen thus far, that the High Court is going to adopt, its approach to administrative law review that's sort of been developed over the last century or so. And what the High Court sort of tells us is that, first and foremost, most of this is determined by statute. In terms of the way in which administrative law review works is that we look first and foremost to the powers that are given to the decision maker and what are the sort of conditions that are attached to the making of a particular decision. And even when it comes to the sort of constitutionally entrenched minimum core of judicial review that we see come out of Section 75 of the Constitution, that it sort of turns on the definition of jurisdictional error, as we've seen the High Court stress in Hussain and the Minister for Immigration and Border Protection, is that jurisdictional error itself, what is a jurisdictional error, is determined by means of statute. And so at least I think to some extent this will be determined by Parliament, not the constitutional amendment, insofar as Parliament probably does have the power to impose on particular executive or government decisions that consideration of the voice is a precondition or a mandatory consideration or a relevant consideration before doing so, but also that Parliament has the power to remove that as a mandatory or a relevant consideration. So I think the uncertainty perhaps lies with Parliament, as in how will Parliament sort of treat the voice in government decision-making, and then, how that's interpreted by the courts. But to some extent, I see that as a non-constitutional form of uncertainty because it primarily can be changed and modified by Parliament from time to time. Now, Parliament may not be able to modify absolutely every aspect of it because of Section 75, but the High Court seems to stress time and time again that its sort of starting point, its basal assumption, is that we look to the statute that gives the decision maker the powers to work out these considerations, and so in that sense it remains with Parliament.
Had a question?
Professor, thanks so much for your speech. One of the things about our Constitution compared to the American Constitution is it's a very insignificant document, the little brown bird compared to the soaring eagle, and it's just a power-sharing document. It shares power horizontally and vertically. And normally, the conservative case for constitutional change is to ask, does the polity, does the Commonwealth have the power to do what it wishes to do in its legislative function? And if it does have the power, no constitutional change. If it doesn't have the power, go and ask the people to give it the power. And that's been our history of 44 referenda. Now, whatever happens in this referendum, the Commonwealth Parliament has the power to legislate a voice or a voice-like body. There's no doubt about that. There's been no argument that since 1967 the Commonwealth doesn't have that power. So win or lose, the Commonwealth has the power to legislate a voice. And in those circumstances, I cannot see how you can say that this is a constitutionally conservative amendment that's being proposed.
Wonderful. Yeah, thanks so much. And I think this goes to the heart of, I think, the counter-argument to what I've put here, is that because it falls, the institution or the capacity to introduce an institution like this, that you don't need to resort to the amendment path. And I think this comes back to partly to the answer I gave to an earlier question, which is that there's certainly the case that if the Commonwealth decides it wants to do is create an entrenched body, then that may be something that cannot be done by means of statute. But I also think that perhaps more broadly, one at least potential response to this is that actually this is to some extent trying to rearrange those power-sharing arrangements, in a way that is somewhat modest, as in the only sort of power that's being rearranged is a power to make representations. But in doing so, it's trying to rearrange, essentially the exercise of public power, in a way that's quite different. Now, could you reach the same result by means of statute? Probably all but the entrenchment part. The answer is yes. And so it does also potentially depend on whether you think that one of the purposes of the voice or the amendment is also to go to actually a foundational relationship that sits at the heart of the system of government, which is, of course, the relationship between the state and First Nations. I think if you think that there's that's not something that this amendment's doing, as in we just look at its practical operation, and its practical operation is to create a body that gives advice, then I think that's certainly a very cogent argument. So I think it really does depend a bit on how you characterise the voice and what it's proposing to do. But I do think that there's at least a way in which you can sort of potentially suggest that this is doing something a little bit more than just the institution. It's an institution within a particular context of trying to be part of a constitutional recognition process. And if you sort of take the view that this is about constitutional recognition, then to my mind, it's also the more conservative option then is to actually amend the Constitution rather than try and do it through an accumulation of statutory devices.
Take the last question back.
Is this on? Yes, it is. George Swinburne. I've just got three sharp, short questions. The first one is,
Choose one.
well, they're all entwined. Are Aboriginal and Torres Strait Islanders not represented as citizens in Australia now? Secondly, are not the 11 members of federal parliament capable of representing Aboriginal and Torres Strait Islanders and the plethora of organisations that now are set up to represent them? And thirdly, by passing this constitutional amendment, what additional power will the federal government have to legislate for Aboriginal and Torres Strait Islanders that it doesn't have now?
Okay, thanks so much. So I think the third question gets back to the first question, which is, the last question about, well, what additional powers here? Very self-evidently, it's going to have the additional power to legislate with respect to this institution, but it probably had the power to establish at least something broadly equivalent by means of statute. I think the first two questions really go to the case of whether we should have a voice or not. And so I'm not really speaking to that question in the sense that that comes down to a question about whether you think the existing set of arrangements are adequate or not. And people have put forward very, as I said at the start, very eloquent cases about why that might not be the case. To some extent, the argument here is that, well, the existing system of government, existing system of government arrangements, has not taken on board the views of Aboriginal and Torres Strait Islander peoples adequately, and so part of listening to them is to listen to what sort of structural arrangements they they're advocating for. The counter-argument is that actually there are adequate arrangements for them to make representations to government, both through the electoral process, through members of parliament who may be Indigenous, but also all the other ways in which you can advocate and lobby for government. That's a big debate. I don't have sort of a strong view on that, as in, my personal view is that I'm listening to what Indigenous Australians are calling for and what they think is adequate, but I completely see the counter-argument. So thanks. I'm sorry I don't have a really adequate answer to that question, or those two questions.
Thank you.
Can I just, sorry, I know we're running out of time. Just a very quick question. Alistair Hinskins, Shadow Attorney General for New South Wales. Just following on from, I think, Stuart's question, what I find interesting about your presentation, Professor, which is very provoking, is the notion that actually the words in the Constitution matter. Now, what we do know from lines of authority like Longy, for example, and certainly in the US constitutional jurisprudence, that often it's the vibe of the thing. You can imply what was really meant by those words and go far beyond what seems to have been a very narrow Black Lauder doctrinal type analysis of this amendment that you've conducted for the purposes of your presentation. Could this not be, given that the voice could be legislated under existing powers, not be interpreted as a brave and big move and therefore be given much greater scope than the words might suggest?
Thanks so much. So I think that there is certainly, so I think one way you could think about it, as in to pick up from a few questions, is that it's certainly the case that Commonwealth Parliament has, within the scope of Section 5126, the power to legislate and create a body that sort of approximates the institution that's being called for at the moment. So you could establish a statutory voice. One of the sort of the purposes, at least as I understand it, of opting for constitutional amendment is to sort of try and entrench that institution. And some people agree with that choice, some people disagree, but I think that's one of the purposes of the amendment. If the Parliament enacted a statutory body and then the High Court entrenched it through some implication that this has the wellspring of support and reflects a big a process, perhaps Commonwealth Parliament tries to entrench it through a manner-informed provision. My suggestion is that's the way more constitutionally radical move, that if we get to the same point that we're trying to get to with this proposed amendment, through a combination of, say, statute and High Court constitutional decision, we have done so by a much more constitutionally radical path. And so that's partly what I'm sort of trying to argue here, is that yes, there might be more modest paths, but actually if you were to try and get to the same end point as this proposed provision through statute or some combination of statute and High Court decision, that is more radical because it denies the people of Australia the chance to vote yes or no on this change. To put it another way, if the people vote no in a few weeks and then Commonwealth Parliament goes ahead and statutorily enacts it and the High Court entrenches it, I think, there is sort of cause for sort of outrage that, well, the people said no to this and now you're doing it through the sort of side door. Now, of course, the likelihood of the High Court allowing Parliament to enact it through statute is somewhat of a long shot, but as you said, more surprising things have happened from time to time. So in that sense, we shouldn't entirely rule it out as fanciful. So I hope that at least somewhat answers your question.
Please join me in thanking Associate Professor Scott Stephenson.